Welcome back, guys, to another episode of Mitchell Group Media. Today I want to discuss a sensitive topic, and that's being prepared in the end. Most of the time, people spend the majority of their lives trying to take care of their loved ones without taking into consideration what happens when they're no longer here. I can't tell you how many times I see loved ones pass, and not only are their survivors grieving, but also have to deal with probate, which can end up costing a considerable amount of money, stress, and hardship. I've seen entire families torn apart over almost nothing. Probate is the process to transfer assets owned by a deceased person to living people with or without a will. Having a will does not avoid probate. It just outlines who gets what. Probate varies state to state, but in Florida, the process can take anywhere from a few months to a couple of years. Your heirs won't even have access to funds until probate is complete, and then there are costs associated with hiring a probate attorney. For small estates, probate fees could completely wipe out anything left, because at a minimum, you're looking at about $2,500 between attorney's fees and hard costs like filing fees, bonds, publication fees, etc. That's almost half of the average cost of a funeral in Florida, which is currently about $7,000. It may be a difficult topic, but one of the most important things you can plan for is your death, or more importantly, what happens after your death. Do you have your affairs in order? For those of you that don't have your affairs in order, I'll go over some of the most common issues. First of all, make sure all your bank accounts have a direct beneficiary. The beneficiary need only go to the bank with your death certificate and an ID of their own. A transfer on death deed if you own your own home. Completing this document and filing it with your county can save your heirs thousands. This document allows you to transfer ownership of your home to your designee. All they need to do is take their ID and your death certificate to the county building, and the deed is signed over. Doing this will avoid the home having to go through probate. A living will allows one to put in writing exactly what you want done in the event you cannot speak for yourself when it comes to healthcare decisions. A durable power of attorney allows one to designate a person to make legal decisions if one is no longer competent to do so. Power of attorney for healthcare allows one to designate someone to make healthcare decisions for them. A last will and testament designates to whom personal belongings will go to. In Florida, the person who has the original will must file or register it with the local court clerk within 10 days of death. Only the original will can be filed, and photocopy or digital imprints are not acceptable. The will must be deposited with the clerk of the court having venue of the estate of the decedent within 10 days after receiving information that the testator is dead. A testator is just the person who creates and executes the will. A will is not effective until introduced to the probate court, and the probate judge finds the will as your valid last will and testament. A Florida will can be changed at any moment before death. This is the reason why you should be careful when recording your will with the county where you reside or the courts. The beneficiaries under your will not have any right to your assets until the time you pass away, and the will is introduced to the probate court at the county where you are a resident or held real property. The will alone does not grant your beneficiaries any rights. The probate judge must find that your last will and testament was executed properly according to Florida law and then distributed through the probate proceedings. A funeral planning declaration allows one to say exactly one's wishes as far as the disposition of the body and the services. If the above documents are done, you can avoid probate. If all of the above is not done, you have to open an estate account at the bank. All money that does not have a direct beneficiary goes into this account. You have to have an attorney to open the estate account. The attorney also has to publicize your passing in the newspaper or post a publication at the county courthouse to allow anyone to make a claim on your property. It's a complete pain and could be a nightmare for your heirs because everybody thinks that they know best as to what someone would have wanted unless it's otherwise stipulated. Make a list of all bank and account numbers, all investment institutions with account numbers, list of credit cards, utility accounts. Leave clear instructions as to how and when these things are paid. Make sure your heirs know you have a policy and where life insurance policies are located, and record all recordable documents with the county when necessary. Make 100% sure someone knows your Apple ID, bank ID, account login, site key, and passwords, especially if you have a crypto account, trust wallet, or cold storage. Make sure they know your word phrase password, known as a recovery phrase, seed phrase, or SRP, secret recovery phrase, and make sure they know what the 12 to 24 word phrase is for and the location of the assets. Make sure you have titles for all vehicles readily accessible. Finally, look into putting the property into a trust to avoid taxes and how that and these options affect taxes to be paid by your heirs. You can also avoid probate court in Florida with a Florida revocable living trust, though there are exceptions. For the assets titled under your living trust, you will file your income tax on the same tax return as you would do with any other asset that is giving you income. The effect of putting an asset into a living trust that it changes the title to the asset for legal purposes. Instead of the asset being in your individual name, it would be under the name of your living trust. A Florida revocable living trust must have a trustee at all times. The trustee is the person in charge of administering the trust during your lifetime. You will usually be your own trustee unless you designate someone else to. Death must designate a successor trustee to administer the trust on your behalf. The main reason for a Florida revocable living trust is one, to avoid probate court, but other reasons exist as well to avoid guardianship court. It gives you control over death. It serves as asset protection for your beneficiaries and protection for individuals with special needs. Sometimes the most commonly overlooked things can be the most important. Even if there are costs associated with preparation, at least your loved ones won't have to suffer twice when you're gone. And at the very least, it can eliminate stress between heirs. Always consult with a legal professional in your market so they can best advise you on your situational needs. If you found any of this insightful or helpful, please like, subscribe, and ring the bell so it may help someone else. Thank you, and I'll see you in the next video.